Good morning. We'll call the Wednesday morning, September 14th.
Your mic.
Thank you. Good morning. We'll call the Wednesday morning, September 14th meeting of the Criminal Justice Committee to order. We'll start with roll call, please.
Mr. Hess,
Present.
Mr. Long,
Present.
Mr. Lear,
Present.
Mr. Snipes, Ms. Peters, Ms. Parker, Mr. Fairfield, Mr. Carrico, Mr. Eckhoff, Mr. Swanson, Mr. Kirkstra, Mr. Hunter, Mr. Smith, Mr. Gowler, Mr. Beeler, Mr. Steroy. We have a quorum.
I have not received anything for public comment. Is there any public comment at this time? Any public comment? Moving on to the approval of minutes. Should have received them electronically. Take a motion to approve. Mr. Smith, second by Mr. Kirkstra. All in favor say aye.
Aye.
Opposed, same sign. Motion carries. Chief Judge Cunnington.
Okay, good morning.
Good morning.
All right, good morning. Got three things to report on. The first one I wanted to bring the committee up to date on. A little bit of information is on the renovation of the basement at the courthouse. It is out for bid, and there has been a pre-bid meeting with potential contractors. I happened to be in the basement at the time, and it was very well attended. A lot of interest in that. So that's proceeding along. The second item is our case management system. You know, we're in the process of obtaining bids to replace the CourtView system, which is extremely antiquated and not able to be used effectively in our community. Again, we're the only county in the state of Illinois that utilizes CourtView. So we are looking for the bids to replace that. We did receive 4 bids last part of August. I think it was August 25th was the deadline, and we did receive 4. We're in the process of taking a look at those. They're hundreds of pages long each, and we want to set up demonstrations with at least a couple of them so they can come in and show us their product, show us what bells and whistles they have and which ones are optional, which ones can we, you know, do without, that kind of thing. And so that's proceeding along. Then the third item, which is of interest, and I think you'll hear some more about it this morning, but is the SAFE-T Act going into effect, or also called the Cashless Bail Act. That's going into effect January 1st. It's been on the national news every day now that Illinois is the only state that's proceeding in this manner. And the judges, which, you know, as chief judge, I'm part of the judicial, the Conference of Chief Judges, which meets in Chicago every month. Got a meeting on Friday, and it's been the topic of discussion for many months now. There's also a statewide committee that's headed by one of our chief judges, Clint Hull from Lake County or Kane County, and he is shepherding this committee, and they're holding town hall meetings. Those are broadcast and publicly available. Now we're meeting about every 2 weeks or so for that. And at this point, the chief judge's position is that this is the law and we have to abide by it. There still could be some potential changes, some possible trailer bills coming up in the veto session. We don't think those are going to go anywhere, but there's still some hope that there might be some changes. There's been proposals to repeal the whole act, but that has not gained a lot of ground. So we're meeting. As a local group, I've asked Judge Dickinson to head that up locally here, and meeting with stakeholders and coming up with what we think we're going to need to do to comply with this new law. So I'm happy to answer any questions that you have.
Mr.
Yes.
Wheeler.
Thank you, Mr. Chairman. Have they they, meaning anybody, finally determined if on 1/1 we open up the doors for a bunch of people that are in jail for things that are cashless bail now?
Well, we met actually yesterday afternoon with Mr. Rowe and Mr. Pennewick and Judge Dickinson and discussed that very topic, and it's that still hasn't been decided. The law is not clear, it's convoluted, it contradicts itself, it is poorly written, and we don't have an answer to that yet. One possibility is that we hold preemptive hearings in December and say, okay, these 50 people should be detained after January 1st, whereas if they were arrested after January 1st, they wouldn't be detained unless there was a hearing for that. The problem with that is you could hold the hearing and then stay the order until January 1st, but what you're doing is you're holding a hearing on a law that hasn't taken effect yet. Even though you're staying the enforcement of it, you're still holding the hearing and according to the requirements of the hearing in the statute that takes effect January 1st. So there's a potential problem with that, but the other side of the coin is, on January 1st or 2nd, do you open the doors and let everybody out that would not be detainable, or do you try to in the first 24, 48 hours of that new law going into effect, do you try to hold 50 hearings and take all the judges and they're all holding hearings at the same time? But that has not been worked out yet. Stay tuned for that. Any other questions?
Mr. Snipes.
Just 2.5. And I guess the half kind of piggybacks off of the second question. So let me ask the second question first. This cash bail, there is data that's out there in the media world, and a lot of people are concerned because it suggests that the hardcore or the felonies and murders, rapists, everything, when they come through the door, they're let go and you have no jurisdiction, and I don't think that that's totally true. So I guess on the piggyback of that is, what is considered detainable and where's your discretion as to whether or not we can keep those individuals that would be questionable as far as their conduct and character incarcerated until they get that trial? Because I think there's a 90-day thing that's up in there outside of the constitutional right to a speedy trial if they so request and all that. So I know it's a convoluted question, but
no, I understand your question. I can speak to it. There is a laundry list of what we call detainable offenses, and I can certainly get that to you if you'd like. Email it or. But they're defined as forcible felonies that are non-probationable. So murder would be one of those. So the very, very serious crimes are detainable. It's the crimes that are maybe not murder or rape, sex cases, domestic batteries, those are all detainable, but some of the other cases that fall through the cracks are the drug cases. And it's been said that you can drive a semi-load of fentanyl through Kankakee, get stopped, and they can't hold you. Now, the other component of that is if the defendant, the person that's arrested, has shown a clear intent to evade prosecution and leave the jurisdiction of the court. And it does say, the language is very clear. They can't just say, well, I missed court 3 times, and so, or the judge can't say he missed court 3 times, so he's likely to not come to court, which is kind of the standard now for issuing bench warrants. But in the new law, he has to have a specific intent to evade the jurisdiction. Pretty much has to say, when I get out of here, I'm going to Mexico and I'm not coming back. You know, you got to hear that. Officer has to hear that in order for a judge to find that he's likely to evade the prosecution. But I can get you that list. There's quite a few offenses that are detainable, but there has to be a hearing. The judge has to find that the defendant should be detained, and that there aren't other conditions that could be set. Maybe it's home confinement or electronic monitoring. There are some other conditions that could be set that would assure that defendant's return to court. So the judge has some discretion in that regard.
Okay. And then the first question hopefully is one that'll help you out. I didn't want to answer for you, but I do get sometimes a laundry list of individuals who claim they can't find community service. And so a lot of times when they come, there's one individual I know in Pacific decided to say the baby is sick or whatever, so it was like 3, but they came to me and said, can you find community service? So for the record, St. Vincent said that they will take, and that's the one next to the driver license place, that they'll take all that you have for community service. So if you put that on the list, and I think a lady is supposed to be coming before you sometime this week, but I said I would show up myself if it's another excuse. So she's in there, and now she's doing her 100 hours of community service. So just to kind of leave your burden, leave on a good note, if they have to have community services and can't find it, St. Vincent said they'll take all, especially to unload those trucks and get the stuff on the floor. So
yeah, about a year ago, Mr. Latham and his department agreed to take over the monitoring of our public service work, and they're doing a fantastic job. It does a couple of things. It eliminates the people having to come back to court every 2 or 3 months to report on their public service work, and we're not really in a position to monitor their public service work. But St. Vincent has been on the list for a long time. I don't know if they're still on. They're still on your list,
Tom?
Tom?
They're on the list.
Yeah.
They didn't get a lot of the people, so it was saying send them to us, and so.
Yeah, they're on the list, and they've been very. I can't tell you the number of letters I've gotten from them that so-and-so has completed their public service work. So, yeah, that's a great organization to help. But Tom's nodding his head that they're on the list. So,
all right,
thank you for
good.
that.
You're welcome.
Anything else?
Any other questions for the judge? Thank
Okay,
you.
thank you.
Up next, Circuit Clerk, Ms. Cianci. In your package, you have a copy of the monthly report. Take a motion to approve. Ms. Peters, second by Mr. Eckhoff. Morning, Sandy.
Good morning.
Comments on your report?
Well, it seems like the state's attorney's collection did a little better this year in August than they did last year. They doubled the collection, so that was good. We're right about this. We're a couple $1,000s less with the Harris & Harris local debt recovery program. I have a meeting with them on Monday. I think we're going to talk about some other ways that we can do some different things, so I'll be letting you know more about that next month. The rest of the reports are normal and customary, so I don't know.
Are there any questions on the report for Sandy? Mr. Hunter.
Thank you very much, Mr. Chairman. Sandy, I know Puke Judge Cunnington talked about the proposals that are being submitted regarding the court stuff, programs. Was there a committee or a group of individuals who developed the RFP?
Yes.
Okay, and who did that involve?
Anita, Chief Judge, myself, a couple people in my office, the state's attorney's office, the public defender, the probation department, everybody was invited, the sheriff. We were all together. Chairman Wheeler, too, was very involved in that. And so, yeah, we put it all together.
Did you have any other templates from other counties? Mm-hmm. Okay, thank you.
Any other questions? We have a motion and a second. All in favor, say aye.
Aye.
Opposed, same sign. Motion carries. What else? Yeah.
Well, so the basement project, we're working feverishly again on that. I'm gonna have to talk to Chairman Wheeler about, we have the books that Craig talked about the one time. We're gonna have to store them somewhere. I don't think we're gonna be able to process those, and there's probably 400 or 500 books, or quite a bunch, so I'll need to talk to you about that. But so we're finishing up the basement project, getting everything moved out to be microfilmed and shredded, and we will be ready probably by the middle or end of October. Well, for sure by the end of October, but middle for sure. That's about it, really.
Any, Mr. Wheeler?
The fee reduction act of a couple years ago, you remember, if you couldn't afford to pay the fines or the fees, you could petition the court. Does that have an impact on collections too? Can they petition if they qualified for those fines and fees from the past?
No, it would.
If it's gone to collection, that's what it is.
Yes.
It's only going forward.
Correct, right.
Okay.
So they have to petition the court at the time that it's in court.
Okay.
And then the judge, and then when they do the sentencing order, they'll either give us the order to waive either 25, 50, 75%, or 100% if they're going to allow it. And then we have to go in and have, modify the assessments
Okay.
as we do that. So yeah, there's nothing that they can do about what we have out there now. So,
Any other questions? Thank you.
all right, thank you.
Up next, State's Attorney, Mr. Rowe. In your package, you have a copy of the grand jury report and the grand jury statistics report. Take a motion to combine and approve them. Mr. Eckhoff, second by Mr. Carrico. Good morning, Jim.
Good morning.
Comments on your report?
You can see they returned 44 true bills at the last grand jury, and that brings us up to 567 for the year. Last year at this time, we had 721 cases had gone to grand jury, so it's about a 20% reduction, which we haven't changed anything in our charging policies. And law enforcement still sending the cases up to us, so hopefully that's a good trend. Any questions on?
Any questions on the report? Have a motion, a second. All in favor, say aye. Aye. Opposed, same sign. Motion carries.
Just a few other quick things. What our circuit clerk touched on the collections, doubling that number last month, that is a tall task. Desiree Gore in our office works on collections. John, Terry, Desi, they're a part of it as well, but Desi for a couple years now has really kind of been the point person on that, and the numbers were significantly higher a couple of years ago. They have gone down, but it's not any result of her efforts. Primarily, a lot of our collections for the county would come through the Illinois Debt Recovery Program, which is a program through the Illinois State Comptroller's Office. A couple of years ago, I think in 2020, Comptroller Susanna Mendoza decided that she wasn't going to garnish tax returns or wages to pay court fines or municipal debts anymore. So in the past, if someone owed a fine to the county or to a local municipality, that municipality or entity would be able to put a claim into the iDrop system, and when they were going to get either a state tax return or if they were a state employee, that those fines would be garnished out of their paycheck or their tax return. That was a significant source of recovery. Right around tax time every year, we would get a lot of money coming in the door through that manner. Now, she put that on pause, and it still is not in effect to the best of my knowledge. So that we've seen a big drop in collections as a result of that. It basically shifts that burden back onto the taxpayers even more and not onto the criminals. So, but I think Desi's done a great job with that. It's not easy to collect money, especially when this legislature has taken away every incentive almost to pay your fines, but she's still keeping those numbers up. So to her credit, I think we should all be thankful for her efforts. Also, the State's Attorney Community Foundation. So we started a 501c3. It's not associated with the State's Attorney's Office by its very nature. It's a separate entity. It's a nonprofit. We did that because there are a lot of grants out there that a county may qualify or a governmental entity, and then there's a lot of grants that we don't qualify for as a county or as a prosecutor's office. So this 501c3 is going to allow us to access a lot more money, primarily probably more for the prevention and intervention initiatives than the prosecution side of the office, but equally as important, and it's going to open up some more pockets for us. We just received some money to that foundation from the local community foundation, and that was for $10,000 to start a program where we can start working with working to reunite fathers with young males who are in our system for firearm offenses. There's a lot of studies out there that show that when specifically a father is involved in a young boy's life, that child is, I don't know, 800%, I believe, less likely to end up in the system. And one common theme we see with young men who come into our system is mom is there, grandma is there, grandpa may be there, but a lot of times dad isn't for a number of reasons. So this program starts to bring dad back into that relationship. We give them healthy opportunities to do things in our community at no cost to them. So they can get back into that habit of just hanging out with their son and doing positive things. Sometimes it's everything from, you know, could be fishing, could be a movie night, could be a play or something in our community. Any opportunity we can find for them to engage in something at no cost, and we facilitate that for them. And it's a one-year program. There's some parenting curriculum involved in that too, but we hope by the end of the year we've built up that habit of them still you know, meeting up at least once a week, if not more, to rebuild that relationship. Seems to be pretty effective in keeping kids out of the system for firearm offenses. Beyond that, I wanted to talk a little bit about the Safety Act. I think there's a tremendous amount of confusion because of the way the bill is written, and that's leading to a lot of misinformation out in the community. Everyone seems to have a view. I've seen things from the governor's office that says every offense can be detained, and that judges still have discretion to keep dangerous people in prison. That is simply false. It's just not true. You know, if anyone's read the bill, and I've read it multiple times over the past year, the trailer bills, it's simply not true. And then there's some things out there that say no one can be detained. Everyone's going to walk out on January 1st. And I don't want the community to think that that's true either. So if I could, I'm going to walk through this extremely fast. You can go past this one. Okay. These were some of the main reforms, in my opinion, on this House Bill 3653. What's detainable, what's not, the 90-day provision, what happens when someone doesn't come to court, reduced periods of parole, and then how it impacts our ability to protect witnesses and victims. The detainable offenses. So if you're looking for offenses that this statute says are detainable offenses, you're primarily looking at first-degree murder, sex offenses, domestic violence, stalking, and a majority of the firearm offenses. Now, where you get into the weeds on this stuff is when can we detain someone for perhaps a sex offense or a domestic violence? Well, someone comes in with that charge, the state has to file a petition asking the court to detain that person. In that petition, we have to be able to allege that it is a forcible felony and that it is either not probationable or that it falls within one of these listed offenses. And then in most instances, we have to identify a specific person to whom this defendant poses a specific threat. So when you get into some of your aggravated discharge of a firearm, let's say someone drives down your block and fires off 30 rounds. I can't just detain that person because they're a risk to the community, because this bill doesn't really consider that anymore. I can detain this person if I can identify the specific person and the specific threat they pose. So, you know, Tinker, you tell me when Billy drives down your block and shoots it up, who is he aiming at? Unless Billy confesses, I can't name a specific person by name in my petition to detain. So there's a good chance Billy's walking unless I can satisfy that second prong, which is what Judge Cunnington talked about. And that's where you start to talk about willful flight. And that's why the governor can come out and other people and can say that every defense is detainable. The judges have full discretion. They're hanging their hat on that second provision, the flight provision. And that provision requires us to show that the person is not only trying to evade prosecution, but they are concealing themselves. What does that mean? right? Fleeing from a scene is not enough. That's not enough even to say that they're a flight risk or that they are trying to evade prosecution and conceal themselves. The fact that maybe they've had 20 prior court dates in other cases, and every time we've had to issue a warrant because they never come to court, that can't be considered by the court. All the court can go on is whether we can prove that they are actively trying to conceal themselves and evade prosecution. So we had a case once, I think, the sheriff and myself got Facebook messages from someone who said he was at a Hooters in Mexico and he was never coming back. That's probably the only case I can think of in 6 years in this job where I could prove that someone was evading prosecution and actively trying to conceal themselves, because I have actual proof of it there. It is going to be very difficult to detain very dangerous people in our community after January 1st. When we start to talk about kidnapping, when we talk about robbery, when we talk about drug trafficking, the example that the judge gave, it's going to be an almost impossible hurdle by the way that this statute has been drafted. You know, there's still an opportunity to have a trailer bill coming up here in the veto session in November. Our state senator, Pat Joyce, has put together, I think, a trailer bill that would resolve most of the issues that we're facing here. But it is bipartisan. He's worked with state attorneys on both sides of the aisle, public officials, public safety leaders. He's worked with community activists, community agency groups. It's a bipartisan bill, and it would really resolve at least the 5 biggest concerns. You can go past this one. 90 days to trial, huge problem, huge problem here. This is probably one of the most dangerous elements of this bill. If someone is arrested, we have 90 days to get them to trial, or else they will be released. Now, there's a provision in there that says that's only unless the delay is attributable to the defendant. So if the defendant asks for a continuance, if the defendant is trying to secure witnesses, that delay is attributable to them. It doesn't count against our 90. But consider, for instance, a case in which someone who knows that they are facing life in prison, perhaps they've murdered a police officer in our community, and you've got multiple agencies involved. You have DNA evidence at labs in the state of Illinois, perhaps fiber analysis, ballistics, fingerprints, and you're waiting for the lab to process all of that evidence, for all those agencies to collect all of their reports and send them to us so that we can proceed to trial, and that person wants his 90 days. Under current law, we get 120 days, and then we get another 60 if we go in because we're waiting on labs. They've cut that time now in half where that individual would be released from custody. And that may be the most extreme example, but when you're going into January 1st, not only with a shortened period, with crime labs that are never going to be able to turn around all of these cases in under 90 days for every jurisdiction in the county, and against the backdrop of a COVID backlog of cases in every courthouse, how do they ever expect us to be able to meet this requirement? The next one.
Mr. Wheeler.
Same kind of question I gave to the judge.
Yep.
90 days, over 90 days in jail, will they have to be released? When on 1/1, if they've been in jail for 90 days and they haven't, do you know yet?
Yeah, well, there's no clear indication for that in the statute. We have to assume, of course, that it's retroactive for people that are in custody. I think if that's not the case, then I mean that's clearly the spirit of the statute, right? That this applies to people that are in custody. So on January 1, anyone that's in custody, it'll apply. But I don't believe that 90 days should be retroactive, because the 90 days doesn't start until the statute is effective. So hopefully, I mean, I guess that someone could have that opinion because there's no clear guidance in the statute.
Okay.
With what the chief judge said, though, if they hold the hearings before, I can't remember exactly how he said it, they could be in jeopardy if they hold the hearings before on holding them. Why does this law affect them? Because the law don't go into effect until January 1st. Why does it already affect somebody that's in custody?
Now, that's a great question. Yeah, and if you could read 764 pages of that statute 5 times and you won't be able to answer it, because the answer is not in there.
I can't stay up till 4 o'clock in the morning.
Yeah.
To read that.
It only takes 40 minutes, apparently. Yeah, that's what I'm going to get to next on the warrants. The other thing with that, having to have those hearings right away on the 2nd or the 3rd, I guess the 3rd, to detain people, something we talked about yesterday. If everyone in the state of Illinois that's in custody has to have their hearing within 24 hours or 48 hours, depending if it's a misdemeanor or a felony, or really on the day the petition is filed, and then they can get a continuance for 1 or 2 days. How do you expect their attorneys to be able to get into all the jurisdictions within those days to hear hundreds of cases? We would effectively have to use probably 3, 4, 5 courtrooms in this county for days to have 100 or more hearings. Sheriff, I think we have 260 approximately people in custody. 223. So, there's a good chance, hopefully, that a lot of them are detainable, and we'll be filing petitions to detain on a lot of those individuals, but they each require their own hearing. As far as when someone fails to appear in court, so let's say they're not detained, or let's say that the 90 days comes and goes and they're released on that provision. If they don't come back to court, we can no longer issue a warrant when they fail to appear. We have to send them a rule to show cause, which is a letter. It's a pretty please letter. It says, pretty please come back to court. And the police have to go out with this letter, law enforcement. I don't know if that's the sheriff or the local jurisdiction from where the case arose, because there's no guidance again. And they have to find this individual, and they have to serve him with a rule to show cause, telling him, here's your next court date. And then if he doesn't show up to that one, we can issue a warrant. That is extremely dangerous. You've now taken what I would imagine is one of the most dangerous interactions between a fugitive and a police officer, and you've doubled the number of times that the police have to interact with them in that capacity. Because now you got to serve them with the pretty please letter, and then if they don't come, then you've got to go find them again with the warrant. Secondly, if someone doesn't show up to court and they leave the jurisdiction, and let's say they go into Indiana where they hide out there, or they just vacation there forever, how will we ever get them that letter? A warrant is in a nationwide database. So when a law enforcement officer encounters that person, they know that individual has a warrant, they hold them, the sheriff's office goes and picks them up. Indiana officer's not gonna know anything about a rule to show cause letter. They're not gonna have that with them to serve him with his next court date. So if someone were to leave the state of Illinois, how will we ever get them back? Do you think your Kankakee or your Bradley or your Grant Park police officers are going to go into Ohio, California, Minnesota, places where the sheriff's office goes and regularly picks people up? Are they going to go into those states looking for someone, serving them with a letter, when they may not even have qualified immunity in those states? Let alone, do they even have jurisdiction to do that? So that's something that I don't think the bill really took into consideration in any respect, and it could result in someone walking away from a serious criminal case and never having to face justice. And reduce of periods of post-release supervision. When someone commits some of our most violent crimes, armed violence, sexual assaults, just anything you can think of, some of the most serious Class X felonies, the period right now is a 36-month period of what they call mandatory supervised release, parole. 3 years. Under the new law, they've cut all those numbers in half, and for some lower level felony offenses, I believe they've reduced that to 0. So the idea, we all know about recidivism rates, and we know that many offenders they gauge that over 3 years, and they say that the recidivism rates are pretty significant. That's where people commit another crime and end up back in custody. So you'd love to have them under supervision for the period of time when they're most likely to commit another crime, but this bill reduces that period in half. And ability to protect witnesses and victims, you can all imagine for yourselves. Would you be more or less likely to point the finger at someone that you know committed a violent crime if you know they're going to be out within hours back in your community? It's going to be a hell of a lot harder to get people to come forward and cooperate with law enforcement. So, any questions?
Mr. Smith.
I'm just curious what the intent of this bill was. I'm asked that pretty much every day. I don't have an answer for him. I'd like to tell him something.
Statute lays out what its intent was in some of the preamble portions, and basically it speaks to the fact that the cash bail system is an unfair system. So if you and I get arrested for the same offense, and we both have the same criminal background, under the current system, it is possible that if you have resources and I don't, and you're able to post bond, you're out and I'm sitting because I'm poor. I would agree that that is an unfair outcome. Everyone understands that the system needs to be reformed. We work locally here with the sheriff regularly, my office and his department, to make sure that those inequities don't happen. The system does need to be reformed. This reform is not the type of reform that still keeps people safe. Why did we have to allow kidnappers to walk out of jail in order to reform cash bail? That's just simply, why are those two things even connected? It does not make sense. So I think the intentions may have been pure, but the end product here is a really nasty sandwich.
Mr. Hunter.
Mr. Chairman, thank you very much. State's Attorney Rowe, excellent presentation, but I think this would probably be also good for an in-service for us as legislators, because a lot of folks in our communities need to know what House Bill 3653 is all about, some of the vicissitudes, the problems, ramifications, et cetera. And it's always good, you know, to meet with the county board chairman discussing various things and so forth. But this thing is catastrophic in terms of 1123. And I always maintain that there should have been maybe a pilot project just for Cook County as opposed to all 102 counties. But you know, I just, you know, pray to God that, you know, Senator Joyce, as well as other individuals, the chief judges that Chief Judge Cunnington was talking about, can come up with something for recommendations to ameliorate this particular catastrophic bill, because of the negative ramifications that it has in all communities, not just Cook County. But, you know, this thing seems to be geared towards Cook County. Also, let me just say thank you, your office, Miles Maiden, for a wonderful movie night we had on the east side of the city of Kankakee. It was well attended by people from all over the community. The kids, grandparents, uncles, aunts, citizens enjoyed it, and we look forward to utilizing your office again. If you guys don't know what movie night is, and Jim has, I don't know what kind of equipment it is, but it's a big screen, and they show movies, you know, in the communities. We blocked off streets in Marycrest, and we invited people from the east side to come, and we provided refreshments and so forth, information regarding home rule, violence prevention from Dwayne Dean with Gloria Kennedy. Alderman O'Brien came and spoke about the ramifications of you know, the things that may happen if we don't get the what was I thinking of? The problems about us not having 25,000 residents in the city, home rule, excuse me. But I'd encourage you guys not to inundate the state attorney's office, but it's a really good program, and they provide, you know, popcorn. We provided refreshments and so forth, and a lot of other things too. But it's really a positive program that brings the community together, and you receive a lot of information about crime and other community information.
Yeah, we're starting to do our senior fairs now. The movie night's starting to get a little cooler out, and kids are back to school. So our senior fairs are starting up. We're trying to do one in every county board district. So if you're interested in partnering, just reach out to me and we can figure out a date together.
Mr. Snipes.
Thank you. If it's possible, I'd like to receive a copy of the presentation, because I think it needs to be shared, because of the a lot of individuals don't have any type of concrete information. So I want to believe that if you don't have correct information, you'll use your imagination to disseminate misinformation either way, on either side of the coin. But I think this the presentation will definitely serve to set not so much at ease, but at least some of the tension that people are having with this new Safety Act. I am one that personally believes that this model was built off of 26 in California, and now everybody is being arrested with these the Safety Act. But I would like to ask the question: what with this Safety Act, what effect will cash bail have on the true bills that's tendered by the grand jury? When you get those bills of indictment and those individuals are now able to be charged as you go into the courts and see what remedies will, and I guess you kind of almost spoke to it, that will safeguard those individuals once you get a true bill on return on from the grand jury on the safety of these individuals after the crime has been committed and a true bill has been returned.
The grand jury process has no impact upon the Safety Act. You know, whether someone is arrested and charged or whether they've been indicted and are then picked up, there's really no impact there. We can file a petition to detain or we can't, depending on the offense.
Okay.
Ms. Peters?
Thank you for that presentation, and I was wondering if we could take the portion of this meeting where you explained that and put it on Facebook. I know the sheriff puts a lot of information out, and I like to share it because it does make a difference. He's picking up criminals because of what he's putting on Facebook, but I think that's a good way to disseminate that information out to the public. So I don't know if that's possible, but and I'd like a copy of that email too, maybe just to the whole board, because I think we'd all be interested in it. Thank you very much for that.
Sure. You know, the challenge with that is that once you do that, once the sheriff or anyone speaks out about this, you know, those who are peddling the misinformation about this bill, that, you know, then all of a sudden we're labeled as fear mongers and other things. Read the bill. You know, before someone, I'm not saying that to you, but I'm saying before someone wants to throw those words around, before you know, don't just trust me then, don't just trust someone else, read it yourself. And if you can understand it, call me and explain it to me. But there's a lot of confusion in that bill, but there's a lot of really bad ideas. And everything that's up there, there's citations to it, you can go right to it and read it for yourself.
Okay, thank you very much.
Yep. All right.
Any other questions? Thanks, Jim. Up next, Mr. Pennewick, Public Defender's Office. Have a copy of the monthly report. Take a motion to approve. Mr. Long, second by Mr. Kirkstra.
Good morning.
Good morning. Ed. Comments on your report, sir?
I have no comments at this time.
Any questions on Mr. Pennewick's report? Have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries. Comments?
I feel compelled to talk about the Safety Act, but I'm not going to unless someone has any questions, so I have no comments.
Any questions? Mr. Hunter.
Pennewick, thank you. And I can't remember the information that you sent me. Can you just articulate the 20% that response that you gave me?
You asked, I think, either last meeting or the meeting prior, how many juvenile cases involved firearms, and I guesstimated 20%, and I believe that was borne out by the number of pending cases. So about 20% of all juvenile cases involve a firearm, which of course is a high number by any standard.
Any other questions?
I have
What, Mr. Wheeler?
So doing budgets is really just like throwing a dart at a dartboard with the Safety Act. Anybody associated with jail operations, and you know, it's just know we don't know what the impact is. We think we do. What do you think it's gonna, what do you say, the revolving door, what's that gonna do to your office? Are your pendings gonna go through the roof because people aren't showing up?
I think the caseload's going to go up substantially. I'm just being a realist. Even after the Category A and Category B situations arose, you know, there are people in court with 5 felonies pending, 6 felonies pending, because retail thieves and things that people charged with those offenses are getting released and recidivating. They simply are. So yes, the numbers are going to go up. There's no way that's not going to happen. And then, you know, I'm not going to. And then what we're going to do on the weekends is still being discussed at the meetings. But yeah, it could really increase the work that involved.
There's no incentive for the person charged to actually show up anymore as of 1/1.
There's provision in the Safety Act for recidivism, so the state, the person could be detained, but currently we're not detaining retail thieves as a rule, and we being the court system,
right.
not me or a particular person. So, you know, my opinion, this is just, I'm just brainstorming here, but they would kind of turn the Safety Act on its head, that somebody with 2 retail thefts is in jail, and someone on an aggravated discharge is out on the street. So I'm not sure if that's going to happen. So to answer your question, either the reality is going to be that they're going to recidivate, or think they, or the perception will definitely be that I can go out and do it again and there'll be no ramifications. Absolutely. I'm just being a realist here.
But your pendings are gonna go through the roof, probably.
Oh, absolutely.
Because they're just not gonna show up, because there's no, you get a pretty please, will you please come to court? And then if they get arrested, then they have to be released again.
And the funny part is they won't understand, people will not understand the process until it goes through a few times. So it's going to be a little bit of time before people go, wait a second, what does this mean? There's even less restrictions that I had on me before, before January 1st. So it's going to be very problematic, yes.
Okay.
And again, I agree with Mr. Rowe, touched on the fact that the spirit's good, but this was a law that, all the discussions we're having now, the legislature should have had before it was passed. And as we all know, it was passed at 4:30 in the morning, literally. And it's unfortunate that now we're having these discussions. And I wish it was done before, but that's, I'm not a legislature, I'm not involved in that process. So we're all trying to play catch up right now.
Any other questions? Thank you, Ed.
All right, thank you.
Up next, probation, Mr. Latham. In the package, you have a copy of Mr. Latham's report. Take a motion to approve. Ms. Peters, second by Mr. Swanson.
Good morning.
Good morning, Tom.
With the report itself, I have nothing else to add unless anybody has any questions.
Any questions on the report? We have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries.
Pre-trial update. As I've been reporting to everyone, or every committee, about our pre-trial situation with the state taking it over. If you remember, there's the pre-trial reform separate from the Safety Act, but they both kind of collide with no cash bail in January. Since August of last year, the state had a plan out to take over pre-trial supervision, which I've talked about. It's made my hiring more difficult because I have temporary funding and all that. Last month, they switched gears. They changed directions and said that counties that have established pretrial service programs like us can keep it, and we'll keep it. Now that's good. I think it's the better way to go. However, for 14 months, we've sat here, I don't want to say sit in our hands, but we didn't put a lot of planning and time into pretrial because they were taking it from us. We moved on to something else. We've lost a couple good applicants because I had to scare them to death when I'm offering them a job, saying, you might not have a job. The funding's going away. They said, thank you, no thank you, and went on their way. So now, not only that, but they're likely to offer more positions for us for pretrial if we can fill them. So, and I no doubt, I think the impact we're going to have is more people on pretrial than we do on probation. The probation caseload is not going down. That population is not changing, but we're just going to have more people on pretrial than probably we are supervising on probation. So it's kind of frustrating. So now it's hurry up and get ready and try to fill what we have right now. Pull some numbers together and see how many other positions we need to ask for if we do. And if it works out, there's still the cost to the county for even fully funded positions. So that's where we're at with that. And here we are, September, and it's frustrating. And AOIC, there's a lot of good people there, but they kind of work things into a conversation as if it was always talked about, and this was one of them. And so I called them and I said, this wasn't what we were talking about for a while. They said no, but I just got an email yesterday confirming it, that we'll keep it. Well, what's odd, I think, is that Iroquois is a phase one, is one of the 69 phase one counties. They'll be the state will run their pretrial, so it's kind of different in the circuit, which we'll see how that plays out. But the other 33 counties, Kinky, one of them, will keep pretrial. So now we'll just do what we can, try to get ready and handle what we can handle.
Mr. Lear.
A thought just crossed my mind. You said caseload is not going down. I can see that initially, but if they're cutting the amount of time that people are on supervised release, would that cut your...
That's more of a parole reduction in the amount of time they're on parole.
Oh, okay.
Probation that'll stay the same.
Okay.
So, so I think the numbers for probation will stay the same or go up, and then we'll just have that, you know, the pretrial will grow, obviously.
Yeah.
Yeah.
Mr. Wheeler?
So for Iroquois, you'll just have the probation part of it?
Correct.
You won't have any of the pretrial or any of that?
Nothing. They've hired. I've met the person. They've hired a person.
That sounds efficient.
So
sorry, it's just.
I think it should be a circuit. It's you know it's consistent within the circuit, but I guess we'll see how it plays out. How fast pretrial numbers will grow, I think it'll be quick in 2023. But we'll see what we can do. I just, you know, we would have had, well, August of last year is when they announced the reform to pretrial and that the state was changing the structure and they were going to take over. And so since then we've, you know, really just what can we do to keep it afloat, do what we got to do. Then it was going to be January 23, January 24, January 25. They kept changing when they're going to take it over. But now it's not going anywhere. So I will again keep you posted on what we do.
Any other questions for Mr. Latham?
And real quick, Mr. Snipes, on that St. Vincent, when they come in our office and get put on or signed up for public service work, we get their cell phone information. Anyway, we send out a blast to everybody that has public service work whenever there's work opportunities. So we can, if they need people, we can get a blast out to everybody that's signed up right now in our system. And so they get it right away and say no to contact them, and they have hours for you. So we can do that today. If that would help. Yeah. It gets it out to a large group instead of waiting for people to come in and telling them. It gets them out to everybody right now. So.
Thanks so much.
And lastly, drug court auction, August 21st. Information should be going out this week to everybody about, it's at Knights of Columbus, about all the cost of tickets and all the prices and everything, times and everything. That should go out tomorrow. But just give you a heads up.
Mr. Wheeler?
Juvenile detention. So the deal we did with Will County is just about over, I believe.
Yeah.
We've kitty up money because we extracted about $7 million out of that facility that we had paid for, and so we're gonna have to start paying again. We're talking about what we're doing, so it worked. But is there anything in the Safety Act about juveniles in detention? And nothing has changed there.
Nothing has changed with juveniles.
Okay.
The only thing I see changing, which nothing to do with the Safety Act, is you know, detention hearings within, you know, every day on the weekends, not having to wait all weekend to see a judge. I can see that. That's always talked about.
Is that in person or can they teleconference?
That I don't know. I think it probably would be in person. Maybe, I don't know.
It's a lot of travel, you know, because we don't have that facility here, and we wouldn't for the.
And the good news with the spend down being, you know, that went through last month. The spend down went through August 31st, which we thought would be a lot earlier in the year. I think we budgeted for like 3,000 detention days. The spend down was going to pay for about, I can't remember, 1,100 days or plus. Well, our detention days were down this year, and it went a lot farther into the fiscal year, which is good news. Because I would have thought it had been at the end of the first quarter of the year, and now we just have the final quarter of the year to pay for. So that helps. But the detention days are falling every year. So we'll work on a budget how to figure that out. So.
Right. Okay.
So if you have to do weekends, and that affects the sheriff's office too for the transports, correct?
Yes. And there's nothing out there right now that says that that's going to happen, but it's always talked about. And I think anytime you look at the adult population that can go in front of a judge sooner than a juvenile, I think they're always looking at that, you know.
Just a quick question, just to make sure I know. So if a juvenile gets picked up at midnight on a Friday, they got to be back Saturday morning. So we take them to another facility, either up north or down in Danville, or then they have to be back in the morning for a hearing.
But so not the weekends. It's 40 hours, but not including weekends. And
not including weekends.
So they would get arrested on Friday. You come back Monday at 1:30.
Okay.
Yeah.
All right.
And if the Wednesday before Thanksgiving, you're coming back Monday at 1:30.
Okay.
So that's where there's a little bit of, you know.
Mr. Snipes.
Stats says that that homicide and crime has went up about 80% since the inception of social media. And as we well know, our millennials and those that are post Generation X are into this social media pretty heavy, and most of the fights and things that occur looks like it's coming from social media, and then the kids carrying guns and the adults that are in the criminal aspect use the youth because they say they get less time. If you had to forecast, do you see an uprising of that activity of youth being detained, or are they segregated into just home monitoring versus actual jail, being incarcerated somewhere?
With the social media and fights,
all that, yeah, with the shootings and the whole 9 yards through the social media. I know we go through them to get what they say, evidence, because they tend to talk to each other so you can extrapolate it. But the thing is, with a lot of the crime, especially here with the murders that have occurred, is in the hands of youth. And so is there any cause for alarm to see that escalate in Kankakee County, or do we have it somewhat?
Well, I think I can answer your question. I think, anytime we have that, which we're all over social media watching and looking at things, and any information we have that's related to a juvenile that's being detained or charged, obviously that information is forwarded to the state's attorney's office and see, let them evaluate it and see what they can do with it. What they put on social media is shocking. They're not worried at all about it. But any information that we would have, photos, videos, or anything like that, simply we just forward. So they can use them or can't. If they can use them, great. If they can't, they can. I guess the only bad side of it is sometimes you put stuff out there that makes someone more wanting to answer and respond to that.
I was just wondering, as part of their sentence, is there a way that we can?
Yeah, that's to keep them off social media.
Right.
I see. We do a lot of that with sex offenders and stuff, and really track what they're doing. It's very difficult with different accounts and different things like that. We do try a lot, we do, but it's very, very difficult. Especially you're talking to me. I'm not very, I'm not very savvy in social media and everything, so we have to leave it to the younger staff to kind of to track that stuff. But yeah, it's very difficult to do that with all those different types out there. It's just very difficult.
Any other questions? Thank you.
Thank you.
Up next, the sheriff, Mr. Downing. Have a copy of the monthly report in. Take a motion to approve. Mr. Long, second by Miss Parker. Close. Good morning again.
Good morning, everybody. Hopefully you got the monthly report.
Yes.
Okay.
Yes.
Was a little tardy with it this week. It was not Kelly's fault, it was mine, so I apologize for that. Just a couple things from the report. I know Mr. Rowe brought up the local numbers. As of through August of this year, in August of this year, we're averaging 223 locals. Part of that, and probably the majority of that, is that the Illinois Department of Corrections are taking inmates at a much, I don't want to say faster, but more often. I don't know that we'll ever go back to the pre-COVID way that we were transporting to DOC, but it has improved. So that's the reason that our number is down a little bit. Our transports are increasing. I think I may have mentioned this last month or the month before, mainly because of COVID. Everybody's starting to get out and about now. Different places are taking inmates, whether it's medical or other courts in Chicago and Indiana. One concerning note, and again, this gets into the presentation that you saw regarding the mandatory supervised release In 2021, if you look on the IDOC releases for the year, last year, IDOC released 335 individuals back into Kankakee County. Through 2022, through August of 2022, we are already at 316. So that number will increase significantly from last year to this year. Where that comes into play is as we move forward, they're going to get less and less supervision following their release from prison, which could be problematic. Obviously, the hope is that when they return, they don't reoffend. But the reality is, as Jim mentioned, unfortunately, there is significant recidivism. So we'll continue to monitor that. A couple things regarding our staff. We continue to recruit correctional officers. Our numbers as we were getting out of 2021, knowing that we were not going to house for ICE, we did not replace officers who were leaving to get our number down to an equitable number from the standpoint of the number of inmates we assumed we would have. And then Champaign County happened. And so our numbers have actually increased a little bit. And so we have been recruiting corrections every day. We are out and about looking for individuals interested in the corrections field. We deal with both colleges in town, the Career Center at the high school. Obviously, some of those aren't old enough, but at least we start them on the path to consider. The Corrections Administration has done a great job in getting individuals here. However, we are still short, which obviously results in some significant overtime. This issue isn't an issue in Kankakee County alone. It's not an issue in the state alone. This is an issue nationwide. So it is something that we're fully aware of and that we continue to look for qualified candidates to work in our jail. Just the same on our deputy side, we are testing for deputies to create a list. We're testing in October. At this time, we do not have any openings, so we are at full staff. However, we are anticipating up to 4 deputies who are going to retire or have indicated they are going to retire in fiscal year 23. So if we have that list, we at least have a list to hire from. So there is really nothing unusual on the patrol side. And with that, if you have any questions on the report, I'd be happy to answer them.
I was going to bring up on your report, Sheriff, that if you look at your activities from the main entry and the rear entry of the courthouse in 21 and compared to 22, and your civil process, the courts are back open to like they used to be right now, aren't they?
Yes. Yeah, everything is pretty much, other than the backlogs and, which obviously plays into why so many people are in and out of the courthouse. And yes, civil process is up.
Any other questions on the report? We have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries.
Animal control, we fluctuate from full to not full when it comes to dogs. As of yesterday, we were full. So I guess first and foremost, I'd like to say thank you for approving the new facility that hopefully will get moving along shortly. Nothing really else to report on animal control other than we can't wait to get out of that building.
Questions on animal control? No, go ahead, Mr. Hunter.
Sheriff, thank you, and Chairman, thank you. Any more agreements signed with any of the villages and cities?
We do not. We have the information out to the villages and the municipalities, but we have not received anything back or even had a meeting to discuss. So, but they do have the numbers.
What seems to be the problem? Because we probably have meaning the city, Kankakee City has a lot of strays.
And we still take those. Obviously, we still take them. They just bill the city.
They just gotta pay,
Yeah, they pay, and it's, you know, I suppose from a municipality standpoint, they're looking at maybe a pay-as-you-go as opposed to one lump sum. I don't know. But I know that I'm with the mayor every Monday at our chiefs meeting, and so we bring it up periodically, but right now, no movement on it. So, but I will reiterate that to not only the city, but to a couple others that have shown interest as well.
Thank you.
What else?
So I too have a PowerPoint of 3653, but Mr. Rowe and I didn't communicate, and I did not provide mine today. Mine is more on the law enforcement side of 3653, and I will apparently bring it next time, just to show you some of the things that law enforcement will deal with.
Did you do it today at the Zoom meeting?
Probably. However, one thing that I would certainly look at, and it's been talked about, like Mr. Rowe, I've been called a fearmonger and a liar, and you name it. You know, we're just telling you what we know from what we've read, and you know, you can spin it any way you want. Bottom line is, the words are the words. But one thing I would certainly suggest to our legislators, who are some who are trying to fix this, and Senator Joyce and Representative Haas have been instrumental in helping at least try, is to take a look at, and I would encourage you all to take a look, and you can Google it, the New Jersey model of bail, and where they give the judges some discretion, which after January 1st, the judges won't have discretion after January 1st. So I would certainly encourage you to take a look at that. And this was a model that didn't happen at 4:30 in the morning. This was a model that was talked about, was studied, and was a significant period of time before they implemented any of it, as opposed to giving the legislators 30 minutes to read a 754-page document. So take a look at that. Like I said, you can Google it. It's something that I think a lot of people can get behind, and will do some of the things that we're saying that this won't, and that is keep our community safe. So,
Mr. Wheeler.
To that point, you said something at the Economic Alliance meeting I thought was really important. It was the parallel between New Jersey and what San Francisco did in the recall, and the positioning of our law on which, is it closer to Jersey, or is it closer to San Francisco, or is it beyond?
So ours is beyond what they did in San Francisco, which is, you know, we all know what they did in San Francisco. They recalled the state's attorney, and then they recalled the law, I think.
I'll make it
Present company excluded. So yeah, it's way beyond San Francisco, and it's just a, you know, and I could stand up here and preach all day long about officer safety, officer safety, officer safety. This is community safety. This is public safety. Safety for everybody in this room and everybody listening at home and every resident of the state of Illinois. So, you know, I'm not saying it for my officers' benefit, but I'm saying it for the benefit of our community, for the state of Illinois. So yeah.
How many of the state's attorneys are opposed to this county?
My understanding is 2 of 102. Oh, you mean
that are
opposed to 3653?
Yeah.
Oh, opposed to 3653 is 100.
Out of 102 counties.
There are 2 who, I don't know. I think it's 2 that are, I don't know if they, well, I don't know what their feelings are, but I've been told 100 out of 102 oppose this.
That should tell you something.
Hey, you would think.
Any other, Ms. Parker?
Thank you, Mr. Chairman. I just have a comment. Sheriff, 2 weeks ago, our faculty had an active shooter training by one of the deputies. It was eye-opening, educational. Absolutely, he knew so much, and we learned more than ever. Now we know exactly what we should do if that ever should happen, and God, we don't want that ever to happen.
No, we certainly don't.
No,
But we have to be prepared,
we have to be
unfortunately, in today's
prepared.
world.
Exactly, and we learned too that that I can't hurt if I catch him and I tie him up. I can't break his knees. So I'm protective of my babies at school, and he said, "You can't do that." So he said, "Just tie him up," and I said, "If I can get him that far, I'll be happy." But he fired guns in different parts, different guns. We learned the difference between a rifle and what it sounds like, and a pistol shot in different areas, and to identify those. And it was absolutely eye-opening, and just, oh my gosh, we all walked out of there knowing how to stuff a bullet hole and take care of this first aid. He was wonderful.
Good.
And I encourage all schools to do this with their faculty and staff. It was just great.
One last thing, positive note, well, it was positive for one side. On August 28th, the Sheriff's Office participated in Pembroke Days, and that's why I said it was a happy time for one side. It was a great day. We had a great time, and the Sheriff's Office did lose 15-14 on a walk-off hit. So we have 350 some days to practice for next year, because they've already talked about doing it again. I will say that, and this is what I'm going with, I was on the injured list, so I didn't play. So had I played, we'd have probably won, but that's just
Miss Foster, go ahead.
We enjoy you coming out and the team. I was not there. I had another commitment, but we welcome you all back next year.
we'll be there.
Okay.
And I can tell you, just for the record, that Mayor Hodge can run.
Yeah.
He can run. I saw him leg out an infield single, and I'm like, who is that? I thought it was like some 25-year-old. It was Mayor Hodge. So good for him. We had a great time, and we really enjoyed it. And, there were no losers, let's put it that way.
Yeah.
If you have 3 retirements in 23, your new recruits ought to have to play baseball.
We're changing our description, our job description, so.
Thank you.
Thank you, everybody.
Up next, Coroner's Office. Mr. Cavender, in your package, you have a copy of the monthly report and the monthly receipts of money. Take a motion to combine and approve them. Mr. Kirkstra, second by Ms. Peters. Comments on the report?
Good morning, everybody. So good news, our calls in the month of August at the lowest point they've been all year. Looking at the data year long, this entire fiscal year, we're 9 calls down year to date from where we were last year, our busiest year we've ever had. We're sitting at 82 autopsies this fiscal year, which is again spot on with where we were in fiscal year 21 at this point. And hate to say it, but our homicides are actually down 4 from fiscal year 21 also, so that's a positive. But there are some negatives. Obviously, overdoses continue to trend upwards. We're at 31 overdoses with 3 additional pending cases, so we will be at 34. Last year we were at 43. There are 76 days left in the fiscal year, so I'm sure, unfortunately, that we will probably add to that total. In addition to that, suicides are on the rise. We've had more suicides this year than we had in fiscal year 21 and fiscal year 2020 at 14. September, well, that's it on the report.
Any questions on the report? We have a motion and a second. All in favor say aye. Aye. Opposed, same sign. Motion carries.
I was going to add that September is Suicide Awareness Month, and there was a pretty good article in yesterday's Daily Journal paper about suicide. Obviously, all of our statistics were listed in there, and also a lot of resources, and there are a lot of resources locally, in addition to the new 988 that anybody can call on their phone and be connected with a counselor right away. It's another great tool in our toolbox for those people who are struggling with mental health issues. Also wanted to mention that in the drug category, the last fentanyl accounts for 77% of our 31 overdose deaths this year, followed by cocaine and then methamphetamine. The last 2 drug cases that have come in have been positive for xylazine, and the DEA issued an alert on xylazine back in July, and both of these cases stemmed from the last week of July or the first week of August. Xylazine is an animal tranquilizer not approved for human use. And so there's a lot of speculation about how and why xylazine use is on the rise. Not only we've seen it here, but across the state and across the country. And so some of the experts are saying that it's likely being added to fentanyl to extend the high that a person would get when using an opioid like fentanyl. In addition to that, it's relatively inexpensive and it's easily to obtain, so the dealers can access it relatively easily and then mix it in with the fentanyl or other drugs. There have been some studies conducted, and the result of the studies has been that xylazine is not actually killing the person, but it is contributing to the death of the person. As a sedative, xylazine will slow the breathing rate, decrease blood pressure, which compounds the effects of fentanyl or other opioids, which are doing the same thing. So unfortunately, something we'll continue to watch, but just very interesting that in July that alert was issued, and then boom, the last week of July, first week of August, we get 2 cases positive for that drug. So, and unfortunately, it's anybody's guess after January 1st how our office will be affected by the laws that are going into effect. You saw that drug cases are non-detainable anymore. So what do you think is going to happen? I mean, our numbers are likely going to go up too. And that kind of leads into the last point. Something that we always try to keep you guys up to date on is that where we stand budget-wise. We've spent $155,978 of our $160,000 autopsy budget, which equates out to 97%. And there's still 76 days left in the fiscal year. So that is definitely something that we will have to talk about when we start to do budgets for FY23. Certainly this year we're going to be over. We know that in that area. The good news is we're on target with every other area of the budget except for that one wild card. And I know that we've all talked about that, and trust me, if we could predict it, none of us would be sitting here. We'd be in Vegas winning millions.
That's true.
But just so you guys are aware where we're at. And that's all we have.
Any questions on that? What about the fentanyl laced gummies that they're putting out now?
Yeah, so we've seen some things. I think it was pills.
Yes.
Is what chatter was. We have not seen any of that. I'm sure it's probably here, but it's not something that we have encountered anywhere that we have been.
I mean, they're coming up with anything anymore.
Yeah. So, only other thing to report is our vehicle we talked about, I think in May or June, we had ordered, finally got all the equipment for, so it's been completed. Thanks to the Sheriff's Department for helping equip that, and then we have transferred our vehicle that it was replaced by to the Sheriff's Department. They have that in operation now. So,
anything else?
That's it for me.
Thank you.
Thank you.
Any old business come before the committee? Any old business? Any new business? Mr. Kirkstra.
Mr. Chairman, I'd like to make a motion that we adjourn.
Is there a second on that? Mr. Lear. All in favor say aye. Aye. Opposed, same sign.